Hello, ladies and gentlemen, and welcome to Prime Time Sunday on Focus on Liberia. My name is Dennis Jar, and we are broadcasting from Atlanta, Georgia. In tonight's edition of Focus on Liberia, we're going to be looking at some court cases with political implications. We have heard over and over that Mr. Benini Ure of the CPP has sued his comrade, his colleague, Alexander Benedict Cummings, for forgery. Also, we learned that officers of the Monrovia Central Court, they have sued Mr. Ellis Cummings of the ANC and Mr. Musa Bility of the LP, the leaders of those two parties, for action of damages. That is, they carry on some action, or by their they allow these things to go on, and so they were hurt in the instance, and so they have sued. We also learned that Lofa County Senator-elect Brownie Samukai has been ordered incarcerated by the Supreme Court of Liberia until they can restitute the money of $1.3 million. Other than that, they're going to go to jail, and they're going to stay in jail until they pay $25 per month. And I don't know how that, but we don't understand all these things, right? These are all court cases. We don't know what they mean. We don't know the implication. In fact, Mr. Alexander Cummings was given 72 hours to produce the original copies of the framework document. Or to sort all this out, I have called Councillor Frederick A.B. Jayweh to tell us really the update on these cases, what they really mean, and how these things will all play out. How will they end? So, Councillor Jayweh, welcome to Focus on Liberia.
Thank you, Dennis. I'm happy to be here. And hi to fellow Liberians.
Thank you. Councillor, a lot of people are talking about these cases, right? We at Focus on Liberia thought that we are not legal people, so we should get a legal mind, because it's very easy to discuss these things politically. And let me read a few of the things that happened, right? It said the court officers sue ANC and LP leaders. We also see that they say the complaint was filed by two officers of the Liberian National Police, Patient Colley and Victoria Davis, along with a Monrovia City Police officer, Victoria White Davis, all assigned to the courtroom for the purpose of maintaining law and order at the court during all legal proceedings. And this is what they are suing for. Your Honor, an oral court, they want to hold the defendant liable under the tort doctrine of respondent superior. All these things, we don't understand them. We also see that the Supreme Court of Liberia ordered the incarceration of Lofa County Senator-elect Brownie J. Samukai and co-defendants for 2 years for their failure to comply with the mandate of the court, that is to pay 50% of the judgment sum in the tune of $537,828.15. The court says Samukai and co-defendant would now serve for 2 years imprisonment and pay the full judgment amount. We also learned that the magistrate of the Monrovia City Court has given the political leader of the Alternative National Congress, ANC, Mr. Ellis Cummings, 72 hours to produce the original copy of the collaborating political parties framework document. Liberty Party Chairman Musa Bility on Wednesday, January 6, filed a $1 million lawsuit against Masurado County Senator Abraham Darius Dillon for calling him criminal and fraudster. This was said by Councillor Johnson. We played the tape in the beginning there, who told judicial reporters that Senator Dillon's action amount to damages for libel and slander by attachment. Let's begin with the Cummings case. He's been given 72 hours. First, give us an update on the case, and we know that he was sued, and now he's being given 72 hours. What does this mean?
Well, you know, in a criminal matter, I wouldn't speak directly to the Cummings case, but explanation will lead the public to understand what is happening. When a case for forgery is filed, I understand the government decided to sue at the magistrate, Monrovia City Court, and have Mr. Cummings, Elisha Toll, and Chairman Ye10, is that Ye10, the chairman of the ANC, charging them with having committed a crime of forgery. In the process, they were brought to court. Mr. Cummings, I understand, I think the other two co-defendants filed a bond and they were released based upon the strength of the bond. Thereafter, the lawyers for Mr. Cummings applied to the court, the magistrate court, requested that all the list of all witnesses to be used by the state to testify in this case, all books, all emails, all documents should be turned over to them through the clerk of court. In other words, demanding that, which is the discovery process in Liberia in a criminal case, demanding that all the documents be produced, and that the court then gave the state, the Republic of Liberia, 5 days to produce the list of witnesses, documents that they are relying on to prove their case, books, emails, and any other thing that the state will use to the court so that the court can turn it over to Mr. Cummings and his lawyers. I think on the 5th day, the Solicitor General first, while in court, he filed a motion based on section 73.2 and 3 to require that Mr. Cummings and his lawyers produce the 5 copies of the original document, which is the framework document, to court, so that on that motion, the motion was argued, the state Solicitor General argued for the state, and Mr. Cummings' lawyer argued for him. One Councillor Abraham Cllr argued for Mr. Cummings, and the judge with their ruling. The judge then came, later on, the judge came back and ruled that Mr. Cummings, consistent with the law, should produce the 5 original copies of the framework document of CPP, and gave in that ruling, gave Mr. Cummings and his lawyers 72 hours of Mr. Cummings and co-defendant Toll and the chairman of ANC to produce the original copy of the document. As far as I'm concerned, as of today's date, Mr. Cummings' lawyer and Mr. Cummings himself, along with co-defendant Toll and the ANC chairman, have moved on to the Circuit Court, Criminal Code A, and summarized the magistrate to appear before Criminal Code A to defend his judgment. Thus far, they were the case currently before Criminal Code A. They are supposed to appear on Wednesday, the 2nd of February, to defend the judgment, demanding that Mr. Cummings and his colleagues produce the original 5 copies of the framework document. You are mute.
Thank you, Councillor Jayweh. When we heard that the Solicitor General was requesting the 5 copies of the framework documents, or the original framework document signed by the CPP, a lot of us were asking, I mean, why? Why do they need that? And then the Cummings lawyer argued that, why do you want us to produce documents to incriminate ourselves so we can do it? So tell me, why is that necessary? And was that in line with the law to ask for the framework document if the Solicitor General is not the one suing or is not a member of the CPP? We were confused.
Well, the Solicitor General relied upon section 17.2 and 3 of the Criminal Procedure Law. Under section 17.2 and 3, the government as well as the defense lawyer for Mr. Cummings, both, either of them has a right to request a court for a subpoena to be issued to produce witnesses. Mind you, this is the discovery process. All what the Solicitor General did was that he filed a motion and informed the court that the original copy of the framework document that is considered forged are in the possession of Mr. Cummings, and that in order for him to deliver the 5 copies over to the clerk of court, Mr. Cummings and the court defendant must produce the original copy. There are a lot of argument as to whether producing the original copy of the original copy of the CPP document, the 5 copies, whether it violates the constitutional right not to incriminate yourself as provided for by law. No, the request is not a request that violated the right of any defendant. In a criminal trial where discovery process is required, ordered by the court, the state is required to produce the original of all documents, that testimony, the list of witnesses, books, testimony, emails that may be in possession of the state that it relied upon in order to sue. Where the original, in the case of the CPP document, the framework document, where the original is said to be residing in the custody or possession of the defendant, the state has the right under the law to request that the original of the document be produced. Now, what is confusing to a lot of people is that how can the defendant be asked to produce evidence against himself or herself? And those people will run to the Constitution and argue that a defendant in a criminal case has the right to remain silent, not to say anything, and not to testify against himself or produce documents that were convicted.
Yeah.
In this case, this is a little bit separate and distinct, in that what is being asked for to be issued and were granted by the magistrate court was a subpoena duce tecum, a subpoena that required that the defendant, the original copy of a document, if it is in the possession of the defendant or defendants, the law required that they produce those documents so that the state can be able to share with them. Because I'll tell you what, during regular trial, the court will not admit photocopies of documents. In this case, the photocopies of the original framework document will not be admitted into evidence unless the whereabouts of the original can be established. All the state has done is to establish, first one, that the 5 copies of the original framework document that for which a forgery case has been filed is residing in the custody and possession of Mr. Cummings.
Right. And how can that be established? If they were all members of the CPP, how can you say, I have the document? What if Cummings say he doesn't have it? What happened?
Well, all the state did was that the state in its possession, in its position, file a motion and say, what we have are copies, not the original. Because the four political leaders have empowered at the time, Mr. Cummings to go ahead, after they signed the document according to them, to go ahead and notarize those documents, and then distribute the copies and file a copy of the original with the Election Commission. But they complain and they contend that since Mr. Cummings allegedly notarized, he and his team allegedly notarized, they found the original copy of the framework document, Jomli Kanga claimed that she has not been served. Ambassador Walker claimed that he has not been served, has not received a copy. Mr. Jayweh claimed that he also had not received a copy, but in addition to that, Mr. Jayweh claimed that their signature or his signature were forged on the document that was filed with Election Commission. In that kind of situation, the law section 17.2 and 3 require that either party, either the defendant or the prosecuting attorney can request that a subpoena be served on the party in whose possession the original copy of those documents resides. In this case, it is alleged that it is residing in the custody and possession of Mr. Cummings and his team.
The team also argued that he should produce their framework document because it's public document, so it is not something that will convict him. Does it matter that or the document you are trying to subpoena should be a public document, or if it were a private document or Mr. Cummings' own document, can the Solicitor General or can the court still ask for it and say you have to produce it?
Certainly, the court will still request it. Mind you, we're talking about forgery, and the three, Mr. Jayweh, Senator Kanga Lawrence, and Ambassador Buakai contend that the original copy of the document reside in the possession of Mr. Cummings. In that sense, Mr. Cummings filed a copy with the Election Commission. He has not accordingly distributed them. Now, let me tell you one interesting thing here. If those documents, and I'm not saying they are forged, if those documents are not forged, if the original of those documents were in the possession of Ambassador Joseph Buakai, let's turn it all around. Say Ambassador Buakai was a first chairperson authorized to after the document, where the framework document was signed, authorized to notarize them and file a copy with the Election Commission. And Mr. Cummings is the one who is contending that his signature was forged. Mr. Cummings' lawyer will have the equal right as the state to file a motion before the trial court and ask for a subpoena duce tecum, a subpoena requiring that the original copy of the document be produced. So it's not just one-sided. Right. The state can request it. The defendant and his lawyer can also, or the defendants and their lawyer can also request the original copy of the document.
So is it possible, what in the law can prevent Mr. Cummings and his team from providing those documents? Is there anything?
I would say none. All Mr. Cummings and his team could be doing right now, or are doing right now, is shielding themselves from the reality. If I were the one representing Mr. Cummings, and if out of all, because what the court is concerned with is to allow justice to be done. Right. Was there forgery committed? And if forgery was committed, which is part of the Liberian substantive criminal law, which is section 15.70, if the document was altered, which Mr. Jayweh is claiming, and if forgery was committed, then the original of the document in question cannot remain in anybody's possession. Right. It must be produced for the court to examine it in order for justice to be done. And the mere fact that Mr. Cummings and his lawyers are hiding and saying, look, running around with section with the Constitution and saying, look, the defendant cannot produce evidence against himself, presupposes that the document may have been forged. If they were not forged, and I'm saying Mr. Cummings forged it because I don't know, I don't have the document in my hand. If the document in question, nothing about forgery occurred when it stayed in the possession of Mr. Cummings as the first chair of the CPP, then those documents will be produced for the court to be examined. If they are forged, then the shield that the defendant is mounting is that we cannot produce those documents because something may be wrong. Mind you, the 17.1 .1.2.3 requires that either the state, the prosecuting attorney, or the defendant also has the right to apply for a subpoena to be issued on either it could be a subpoena issued on Joseph Boakai if Joseph Boakai was the first chair and the original of the document are residing within his possession. So the right that the state has to request to document is the same right that the defendant has if the situation went the other way around. Now, a defendant not incriminating himself doesn't apply. Why? Because when the defendant is on the stand, on the witness stand, take if the state lawyer did not request the subpoena during the discovery process, during trial, regular trial, when Mr. Cummings is placed, when the witnesses for the state, the Joseph Boakai, because he's one of those that is named, Ambassador Boakai is one of those that is named, Nyobli Kanga is another person that name. In order, when they testify, the prosecution will ask them, Madam Witness, where is the original of this document, that the framework document that you have testified to? Nyobli Kanga will be required to say the original is in the possession of Mr. Cummings. He has not shared with us. Joseph Boakai will also say the same thing. At that level, a trial lawyer will move the court for a subpoena duciticum to be served on Mr. Cummings and his colleague because the document, the original copy of the CPP document in question, it is said to be residing in the possession of Mr. Cummings.
Thank you.
Other way, Mr. Cummings may not have gotten out.
There's a question here from Jayweh Boma. He's a ANC Global Public Relations Officer. He said you cannot demand a document during trial, not before the trial begins. You can only do this during the trial. And you are saying during the discovery process, you can do this.
So let me say what the discovery process is. So Jayweh may not be a lawyer, so he doesn't know how the law works in Liberia. But in a discovery process is a process that must take place before trial. In other words, when is trial is set to commence? So if the state applied to the court and asked for a notice of assignment, meaning for the case to be scheduled for a particular day, for it to be heard on its merit. Once the defendant pleads to the rate of not guilty, and the state commences to put witnesses on the stand, trial has commenced. Discovery process is no longer allowed. Prior to the trial, prior to the actual hearing of the case, the process of discovery must start before trial. So all the prosecution has done has moved the court to pray for a writ of subpoena duciticum to be issued on Mr. Cummings and his colleague, relying more likely on the fact that the witnesses or the private witness, which is Mr. Jayweh, has said that he has not received copy of those documents because the documents were forged. The question is, where are the original? If the original truly rest in the possession or relying or residing in the possession of Mr. Cummings, then Mr. Cummings will produce the original. It doesn't establish whether it will not establish, because you produce a document, it will not establish that forgery was committed. When the court examines the document, if forgery was committed, after witnesses testify, Mr. Cummings and his colleague could be convicted. But
the original is also with the NEC. Can the court subpoena that too, or they have, or it has to come from Mr. Cummings?
The court would have to subpoena only Mr. Cummings because the original is said. Mind you, Mr. Cummings was authorized by his 3 colleagues to notarize the document and file a copy with the Election Commission.
Right.
So the copy that he filed with the Election Commission is considered a copy. The original of those documents resides within his possession. He has not denied that. And so subpoena, if you serve a subpoena on the Election Commission, what the Election Commission will be producing will be a copy. When it comes to try again, the copies that the state may have in its possession if those copies are not the original of the framework document, when you request a court to admit them, when you ask the court to mark them, the trial process will be you will show a copy of those documents. Say Joseph Walker is the first person, Ambassador Walker is the first person on the witness stand. You will show him the document, Mr. Witness, Witness Walker. You will say the original of the framework document is in the possession of Mr. Cummings. Look at
the NEC does not accept photocopies, right? So the version that was notarized, it should be notarized and taken to the NEC. So in my view, I thought that was going to be the original copy will be with the NEC and not Mr. Cummings.
So the copies that in the election commission should be a notarized copy, correct? Yeah. But the question is, all the state thought to do was that, look, we're not going to subpoena the election commission. We go, mind you, this is not a state that is, this is not a government, this is not a court that is asking for the original copy. It is the prosecution that is saying we cannot prove our case in the absence of the original copy that resides, that allegedly resides in the possession of Mr. Cummings.
All right. So my next question is, since Mr. Jayweh has gotten out of the CPP, what fish does he have to fry with framework document? Why can't he just go by business? He's no longer part of the CPP, right?
That's what I've been hearing. Yeah, I heard the BBC interviewing Mr. Jayweh asking such a question. But what is not known by those, the BBC and those who may be contending that way, is that forgery is a crime. In Liberia, is a violation of Section 15.70. A violation, a commission, an alleged commission of a crime, the fact that you were in a private engagement and you allege that your signature was forged on some contractual relationship constitute a crime. So whether you leave or not, you are a private witness for the state. Okay. So it is what I hope to get clear is that it is not Mr. Jayweh per se that is prosecuting. It's a plaintiff rather per se that is prosecuting Mr. Cummings and Elisha Toh and the chairman of ANC. But Mr. Jayweh is serving as a private witness. So the case is Republic of Liberia. If you look at the rate, it's Republic of Liberia versus Mr. Cummings, Elisha Toh, and others.
Mr. Cummings and his legal team, they took an exception to the ruling of the city court about this 72 hours ultimatum and gave notice to the city court that they would take advantage of the law has made and provided. What does that mean?
Okay, that's two things. So in Liberia, in order to complete a magistrate, or when a case is heard before a magistrate, if the ruling the magistrate made is not a final judgment, the magistrate can be summarized. So what a lawyer did, what Mr. Cummings and his colleague lawyer did, Councilor Cllr did, was not to announce appeal to the circuit court. All he said is that counsel for the defendants would take advantage of the law as made and provided. What that means is that we will carry your complaint to the circuit court.
But it is not like taking appeal.
No, it's not an appeal. So if they have announced appeal, the lawyer was said, counsel for the defendants at the having heard the ruling, the judgment of this court, will hereby announce appeal to Criminal Code A and request the court to please have all documentation pertaining to this case filed to the circuit court within 15 days.
What's the difference? This or taking appeal and then summarizing?
So when you take an appeal from the magistrate court, because it's a court of non-record, meaning that the complaints are filed before the magistrate and justice of the peace. Stick with the magistrate. Complaints are filed with the magistrate as oral complaint. And when you announce appeal from a final judgment, the case are ended before the magistrate, you disagree with the judgment, you announce appeal. When the matter gets to the circuit court will review the matter on appeal de novo, meaning that the circuit court will review the matter from as if it did not, they review the entire judgment,
right, as if it is new,
starting there, as if it were new. Now, that's an appeal. In a case where the magistrate is summarized, meaning that his complaint is taken to the circuit court. Mind you, in Liberia, the court that has jurisdiction over all magistrates will be, in criminal matters, will be criminal code A, criminal code B, criminal code C, criminal code D, criminal code E. In this case, A is a centralized court. So what Mr. Cummings and his lawyer had done, they, instead of producing the document in 72 hours, they fled to criminal code A, complaining, summarizing the magistrate, complaining that the ruling the magistrate made is contrary to law. But the case itself remained before the magistrate.
The magistrate.
Yeah, in an appeal, all the record will be sent. The magistrate will no longer have anything to do with it. It will now go before the circuit court. In the situation where the lawyer say we will take advantage of the statute as made and provided, they will complain the magistrate to criminal code A in this case, and criminal code A will review just that ruling, not the entire case.
So now that after, as you call it, summarized, what will happen if that circuit court, set aside or to say, yes, we agree with you? So what are the options or what are the possible outcome for this or for the lack of a non-lawyer summarization?
Or just a complaint. In fact, what they're doing is to complain to the magistrate.
Right.
What could happen is the circuit judge, Judge Jayweh, could conduct a hearing, find out whether the ruling made by the magistrate, mind you, this is not a judgment, this is a ruling. The difference between a judgment is the case is finalized. A ruling, the case is still pending, particular aspect of the case is passed upon by the magistrate. The circuit court could say, Mr. Magistrate, your ruling is contrary to law. And revise the ruling, revise the magistrate, send the matter back to the court below with instruction that Mr. Cummings be not allowed to produce the original copy of the framework document. That's one aspect. After such, if the ruling is made that way, after such a ruling in a summarization complaint, the state has the right to announce appeal. In court, the state will get up and say, Your Honor, counsel for the state, having heard your ruling in this matter, as a matter of right, we are announcing an appeal to the Supreme Court of the Republic of Liberia. You seen it? Now, if that happens, the judgment of the magistrate will be considered stayed, meaning that the judgment of the magistrate for Mr. Cummings to produce the original copy of the five original copy of the CPP document will be put on hold. And the circuit court will be then required to be able to have all the 5 justices in the Supreme Court, 1 Chief Justice and 4 associate justices, 7 files. The document will be photocopied into 7 files. And within a period of 60 days, the state must ensure that all the record gets to the Supreme Court, to the clerk of court. And then the state, after all of that had been done, the state must make sure that the appeal is heard. But let me tell you something. There is no law that requires that a matter that is appealed from the circuit court, say the Cummings can appeal from the circuit court if it went that way. There is no law that says that this matter is of priority. Therefore, the state should rush and get assignment. The defendant, as well as the state, has the right to go to the Supreme Court and ask for assignment. But the Supreme Court will look at its docket of cases pending before the Supreme Court. This is not a matter that has a priority. So the Supreme Court could assign this. We are now in what? What month is it? This is
January ends tomorrow.
The Supreme Court, we are now in the late term of the October term of the Supreme Court, because on the second Monday in October, the Supreme Court opened in its October term of court. So we ending the October term of court, and the Supreme Court will open for the March term, the second Monday in March. The Supreme Court will say, okay, we don't have time to hear this case during the March term of court. Mind you, March term run from the second Monday in March, April, May, June, July, August, middle of September, the court will close for the March term. See how many months before it can open. So then it could take another 6 months before this appeal, if the state should announce appeal, and from my experience, if the circuit judge rule against the state, they will announce appeal to the Supreme Court. If the circuit court rules for the state sustaining, affirming, and confirming the ruling of the magistrate, Mr. Cummings and his group will go to the Supreme Court.
Okay. And we'll leave that Supreme Court part, but let's say for the 72 hours, what happens if Mr. Cummings is not able to produce the original document within the 72 hours, and then the magistrate ruling is upheld by the circuit court? What happens?
The circuit court will send the matter back to the magistrate and say, enforce your judgment.
Right.
Enforce your ruling.
2 hours to enforce the judgment. Mr. Cummings doesn't produce the original. What happens?
There's contempt.
What is that?
It's contempt of court. Look, the failure, if you read the statute, the failure to give compelling excuse for your refusal to produce a document subpoenaed by a court, in this case by a ministerial court, is contempt of court, and you could be sent to prison for 15 or 30 days.
Ladies and gentlemen, if you are just joining us, this is Focus on Liberia. We are discussing some court cases with political implication. The first one is the case with Mr. Alexander Benedict Cummings, the political leader of the Alternative National Congress. He was sued by his colleague of the CPP, Benina Ure, for forgery. Let's go to our next case. I know we'll bring comments and we may go back to this case, but let's go to the next issue, which is the Samukai case, the case involving Lofa County Senator-elect Brownie Samukai. It says, the Supreme Court of Liberia Thursday ordered the incarceration of Lofa County Senator-elect Brownie J. Samukai and co-defendant for 2 years for their failure to comply with the mandate of the court, that is to pay 50% of the judgment in the tune of $537,000 plus, right?
Yeah.
And the court has this case has been going on for some time now. And even the court said that, hey, before the other court said, you can tell me the name of the court, say, hey, each one, Brownie Samukai should pay his portion because there are 3 guys. If you divide that by 3, you can pay your portion. Supreme Court said, no, that's wrong. They all got to pay together. So minus what you pay already, if you don't pay the 50%, you are going to jail for 2 years.
You know, when a judgment is entered by the Supreme Court, there is an order sent down from the Supreme Court called the mandate of the court. The judgment, the mandate is actually the court instructing the Supreme Court instructing the court of the court below to resume jurisdiction, take over the case, and enforce the judgment consistent with what the Supreme Court has said. This is the Brownie Samukai case is an interesting case. Interesting in that 3 defendants were charged with, I think, theft of property, economic sabotage, and criminal conspiracy before the election in Lofa County.
Yeah.
The case was tried before the lower court, Criminal Court C. And the judge ruled that Brownie Samukai committed the act of theft of property, conspired to use, I think, $1.4 million of the military people money.
Pension fund.
And so Brownie Samukai, was sentenced for 2 years by the lower court, Criminal Court C. And the others were sentenced to 6 months, 6 months. I don't understand why, but that's what they did. When this case started in the lower court, none of the defendants, meaning Samukai, I think Joseph Johnson, and somebody else, they were tried jointly.
Yeah.
And they were convicted jointly by Criminal Court C. Now, if Mr. Samukai wanted to be tried separately from the other 2 defendants, Mr. Samukai's lawyer will have filed a motion for severance, meaning separate us. I don't want to be tried with Johnson and the other guy. I want my case to be heard differently because my defense are different from the two of them. The failure to have filed in the lower court before criminal proceed, the failure of Mr. Samukai to have filed a motion for severance, meaning they separate the case, try it separately, meant that he concorded or he agreed that he should be tried jointly with the other two defendants, co-defendants. So any judgment from that trial will be binding on them, not separately, but binding on them as a defendant and co-defendants. All the Supreme Court did was that when the case went upstairs, the Supreme Court also sustained the judgment of criminal proceedings and said Mr. Samukai and his colleagues were guilty as found by criminal proceedings. The court modified the judgment by saying that go downstairs, Mr. Samukai and Joseph Johnson, go downstairs. The other guy is called Yuma Doko. Go downstairs and pay 50% of the judgment, which is, I guess, $1.4 million of the judgment. Now, the Supreme Court did not say, Samukai go and selected the pay some. Joseph, go and pay your own differently because you were sent to jail for 6 months, pay small amount. Samukai paid the largest amount. I think Mr. Samukai paid pretty close to more than 100,000, I think 192,000, something like that. Prior to when the mandate was sent downstairs, criminal proceedings judge had changed. Judge Blamo Dixon, His Honor Blamo Dixon, was assigned now in criminal proceedings as the judge assigned to that court. The judge that made the decision, Yamin Besa, was assigned to Kakata, reassigned to Kakata, which is normal. The court will assign the judges around. So Blamo Dixon interpreted the mandate of the Supreme Court to mean that Mr. Samukai could pay his share, right, and then Joseph Johnson could pay his share differently, and Newman Doko could pay his share differently. So in that process, the Solicitor General, being smart enough, ran back to the Supreme Court on a bill of information on ground that the mandate of the Supreme Court to have what you call it, Mr. Samukai and Joseph Johnson and Human Doko to pay 50% has not been obeyed, and that in fact criminal proceedings judge presided over by His Honor Blamo Dixon was wrongly interpreting the mandate of the Supreme Court. Then Mr. Samukai lawyers went to the Supreme Court also on a bill of information, asking the court for enlargement of time. Give us more time. We have paid some of the money, but we need more time to complete. 1 year to pay. The Supreme Court got offended by that. I can tell that the court got offended. The court said, look, our instruction to the court below was that defendant Samukai, convict Samukai, because he was convicted, convict Samukai, convict Joseph Johnson and Yuma were to pay, Yuma Doko were to pay 50% of the entire judgment and not to pick pieces here and there. Therefore, the instruction by the court, by criminal court C, that said Mr. Samukai should go to jail for 2 years, it is hereby was revoked, and now they are Mr. Samukai is now required to be committed for 2 years in prison. In fact, instead of Joseph Johnson being committed for 6 months, he also is committed for 2 years. Instead of Newman Doko being committed for 6 months, he also is committed for 2 years. So all of them now have 2 years to go to prison because they disrespected, according to the court, they disrespected the judgment of the court. They did not pay the money within 6 months. Now, let me add another thing. The court in this judgment said that they pay the money and go to jail. They didn't say pay the money or not go to jail. They pay the money and go to jail. So what are they complete paying the entire judgment? They will still spend 2 years in jail each.
I mean, is that a ruling? Was it the ruling before?
The ruling before was not that. The ruling before was that you go downstairs. You guys have 6 months. to pay 50% of the judgment. When they got downstairs, I think Joseph Johnson, I understand, I learned that he paid $1,000. I think $2,000, and the human doctor paid $1,000. And Mr. Brownie Samukai paid pretty close to $200,000. But the government contended that that is not the mandate of the Supreme Court. The mandate of the Supreme Court is 50% of the judgment must be paid. Divide whatsoever the judgment is by 2.
Right.
And half of that would be like $500,000, almost $600,000.
Right. It's like $537,000. Yes.
So it is that because they did not obey the mandate of the Supreme Court. So which in the first judgment, the Supreme Court suspended their sentencing period if 50% of the money will be paid in 6 months' time. The Supreme Court restored the 2 years imprisonment, not only for Mr. Samukai, but also for Joseph Johnson and for human doctor. You go to jail, each of you go to jail for 2 years, and you pay the money.
Right. And what does this mean? They say failure to pay will result in the defendant's incarceration in the common jail and therein until the full amount is paid or liquidated at the rate of $25 per month.
So it's interesting. They will remain in jail not just for 2 years, but you will multiply how much the amount is times $25 a month. So it could be more than 2 years.
No, so if you are paying, if each of them paying $25 a month,
divide that by.
So yeah, if you even multiply that, so that means could be over 100 years, perhaps.
Oh yeah, that's what the law requires. The law requires that they will remain in jail and pay. The law says that the court can impose compulsory stipulation on you, meaning that stipulation will be $25 a month times the amount in question. You will remain in jail as long as that.
So what can they do now? What are the options for Mr. Samukai and co-defendants?
I don't know when the judgment, I didn't follow when the judgment was handed down. But my practice experience would be if I representing them, and if I thought that the judgment of the Supreme Court was not so much consistent with the facts and the law, I will file a motion before the Supreme Court for re-argument. What I will be doing as an experienced lawyer is that I will actually be buying time. So knowing that if I file a motion for re-argument, serve a copy on the state will have to file a resistance, and then both of us will be required to file a new legal brief before the court. That could take another 1 year before this case is decided. As an experienced lawyer, I will have then been talking to my client, you pay the money before we can get there. Before the 1 year ends, you pay the money. Find the money, pay. Prior to the hearing of that motion, I will file a bill of information, giving information to the court that the money has been paid. So my client will escape the 2 years. So my client will escape. All I'm trying to do is to work within the framework of obeying the court. And I will pray the court, Your Honor, the amount in question has been paid. We pray that the motion that was filed be done away with. I hereby request the court to grant, modify its judgment, notifying the parties that the amount in question has been paid in full.
So Mr. Samukai goes to jail today. If he pays the entire amount, if Mr. Samukai and co-defendant pay the entire amount tomorrow, they still serve the sentence of 2 years imprisonment.
Yes, the court said, pay the money, go to jail for 2 years. It didn't say pay the money, when you finish paying, then you can go to jail. What angers the court is that the party decided to go before the lower court in criminal court C and argue, particularly Mr. Samukai, and argue that 50% of the Supreme Court mean divided by 3. The amount should be divided by 3. I pay more than my colleague, so my 50% should be considered paid. The lower court agreed with him. The Supreme Court said Judge Blamore Dixon was wrong. The mandate is that the defendant were convicted as a team. The defendant should pay the 50% as a unit.
Yeah. Is there anything Any punishment for Judge Dixon for being wrong?
Well, the court would just, in such situation, the justices may say that his interpretation of the court mandate was erroneous, and we just instruct him to proceed and obey the opinion, unless it is said that he connived with one of the, I'm not saying he connived. If it was said that he connived with one of the parties to have interpreted the mandate as this, then an ethical issue will arise. The court could suspend him. The Supreme Court could suspend him for being in ethical breach. But this one is a mistake of the law.
What happens to Brownie Samukai's seat? Can he maybe serve the 2 year, pay the money, come back and take a seat? I mean, when it comes to that seat, what do we do?
As it is, Mr. Samukai, Brownie J. Samukai, Joseph Johnson, and Human Docker are considered convicts. Legally, they have disabilities, meaning that they're going to jail for 2 years. Until the disability is removed and their constitutional right to the office will be restored, Mr. Samukai has lost that seat.
Disability, I mean, which law says that? If you are convicted, you can take the.
I don't have the citation directly with me, but the reason why the state went to the Supreme Court in the first place was that when Mr. Samukai won the election in Lofa County, his case at the time, I think there were two cases. Mr. Samukai, the election case, Mr. Samukai was declared the winner of Lofa County. And the election commission was to certificate him to sit as a senator. While that was going on, a decision from the Supreme Court sustaining and affirming the judgment of criminal code C was sent down to the lower court. The state took advantage of Cummings and not Cummings. The state took advantage of Mr. Samukai, Docker, and Joseph Johnson being convicted. Under our law, when you are convicted of a crime, your civil liberty, your right to vote, your right to be voted for, it's part of the election law. I need to just find that. Your right to be voted for will be suspended until your liberty, all of your constitutional rights are restored. A convict will lose the civil right to even contest a senatorial seat or be voted for or to sit as a senator.
But he was elected already. And we also see that in the case of my Sino County Senator Milton Tiaje, who was convicted by the LACC, and he was asked. So his colleagues never asked him to vacate the seat. He's still there.
Well, the interesting thing is that in the Republic of Liberia, the responsibility to prosecute criminal cases rests on the shoulders of the Ministry of Justice, meaning rests on the shoulder of the executive branch of the government. The Minister of Justice may choose insufficiency of evidence and not go to court. That's a legal right of the Minister of Justice or any of the attorneys working in the Ministry of Justice. In the case of what's your name? Your Senator Tiaje, Senator Tiaje, the government did not choose to go to court. The government chose, perhaps they chose and said that we don't see sufficient evidence here to be able to stop Tiaje from sitting. Now, does it sound surprising? Is it strange? Yeah, politically it's strange, but legally the government, the Minister of Justice is responsible for the prosecution of all cases. They may choose which case or cases they will prosecute, and which case or cases they may not prosecute.
We'll take a short break. When we come back, we'll look at the case involving Musa Bility and Senator Darius DeLong.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Dennis Ja.
Hi, my name is Addie Tyler from Pennsylvania, and you're watching Focus on Liberia.
Welcome back to Focus on Liberia. We are discussing court cases with political implication. The next case on the docket, Councillor Jayweh, is Musa Bility has sued Senator A.B. Darius DeLong. And here is the lawyer of Musa Bility talking about the case. Take a listen.
But this is the catch here. Dr. Bility is suing Senator Darius DeLong not because he won the $1 million. In fact, he told me, I said, no, I thought when that damages have been paid, I don't want it. I said, give it to me, I want it. Okay? But it is to teach Senator DeLong a lesson so that others must know, because this is a man who is the senator of Monserrado County. People follow these people.
Councillor Jayweh, is there anything legal about teaching somebody a lesson as a reason for filing a court case?
You know, this Councillor Johnson is an interesting lawyer. I remember when I taught at the criminal justice program in Liberia, the Zion Community College. He was then a student in 1992. I think I taught there 1992 to 1996 or 8, something like that. First thing first, I think Councillor Johnson could be punished by the court, the civil law court. When you file a case, you don't call a press conference. And you don't discuss the merit or demerit of the case. You hear a lawyer say this case is sub judice, meaning that the case is filed and pending before the court. I cannot speak to the merit or demerit of the case. Councillor Johnson doing it the other way. He talking to the press. I'm sure the press people sitting down before him and asking questions. He's talking to her and he's discussing it. The thing about it is that does Mr. Bility in any way have legal right to sue anyone that he wishes? Yes. Anyone in Liberia can sue. In the case of Mr. Bility, he filed an action of damages for wrong. I think in bracket, they have slander, they have defamation of character, and other things. And Councillor Johnson appears to me that he's arguing the case already before he can even start, before the press, which is, you can be held in contempt of court. And no matter who you are, you could be sent to jail. Civil law court the judge could hold you, could cite you for coming to explain why you called in press conference in the case. Because a case before the court is not a public theater where people go watch movie and clap for the hero. That's not what it is. It is a pretty serious situation where if the court finds that the defendant is liable, and I'm not saying guilty because this is a civil matter. In criminal case, you say guilty. In civil matter, you say liable or responsible. In that case, the defendant could be paying 1.5 million. And the other thing that interests me is that the lawyer said that his client told him he doesn't need the money. He said, give it to me. Give him the 1.5 million. It sounds like an unethical lawyer to me. That's why it sounds. And again, the Supreme Court, if the justices have time to watch some of these videos, you will find yourself in trouble very quickly. It could lead to you being suspended from the bar to practicing law for about a year or so, or even longer. If it is established that you filed this case because you thought there's $1.5 million inside that your client will give to you when you win, if that the facts can be established, you're in trouble.
Right. I mean, I'm not a lawyer, but when I listen to this guy, and it's like he's performing.
Oh yeah,
But,
the guy.
but here is the case. They said Liberty Party Chairman Musa Bility on Wednesday, January 26, filed a $1 million lawsuit against Moserado County Senator Abraham DeLong for calling him criminal and a fraudster. Who said this amount of 1 million? You know, like
So in a civil case, like the one before the civil law court, all civil cases must be prosecuted in the civil law court, must be tried in the civil law court. The defendant can say, I'm injured. My reputation has been dragged in the mud. The public no longer believes in me. My business partners can no longer do business with me because I'll call a fraudster, a criminal, and so forth. So I am asking not the grand jury, asking the sitting jury. So there's a group of people called the trial jury. I'm asking them to award me a damage of $1 million to restore me to the character that I have lost. So you can say 5 million, you can say 2 million, you can say 3 million. It doesn't mean that the jury, after hearing when the case is tried before the jury, when they go to the room of deliberation, where they go to say whether the plaintiff has proved the case against the defendant, it doesn't mean the jury will just automatically come out and say, you got 1 million. The jury could increase the damages from 1 million. It's called general damages. You'll be asking for general damages of any amount that you think is enough to restore you to your character. And there's something called punitive damages. You could be asking for the defendant to be prosecuted. I mean, to be, to be punished, not prosecuted, it's a civil matter. To be punished for tarnishing your reputation. Now, the fact that someone sued for 2 million, 3 million doesn't mean that
you will get it.
The case, you will get it, or that the proof is overwhelming. I see Councilor Johnson arguing that the proof is so overwhelming that maybe next month when the judgment is obtained, he may likely get the 1.5 million.
And he keeps saying repetition instead of reputation. But anyway, I find him very, 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 very funny when he's saying these things. But let's come to the case. I don't know if this will be the merit of the case or not, but I will ask my question anyway. That you sue for damages, say, well, he has injured my character according to what we just read, for calling him a criminal and a fraudster. Can Abraham Darius DeLong prove that Musa Bility is a criminal and fraudster? Is that something that he can prove?
So Darius DeLong did not sue. So the preponderance of evidence or the requirement to prove that DeLong said the things that they allege in their complaint, they will have to first put witnesses on the stand, bring documents to establish that DeLong said all of these things, and if the pieces of evidence they bring to court during trial are sufficient material and strong enough, then Dylan will be made as a defendant to come to court and also counter-produce witnesses, documentation to say that these things I did not say them. These are alleged complaint. The complaint, nothing in the complaint that will cause the court to hold me in damages for wrong, for defamation of character, and that's why the jury will will weigh the facts. This is a jury trial. The jury will review the facts, go to the room of deliberation, and find out whether what Musa Bility has said is sufficient to grant him a judgment, a verdict that will basically, at the end of the day, that will be sufficiently strong enough to have Mr. Senator DeLong to pay the 1 million or 1.5 million.
Is the 1 million the one
Johnson
is waiting for?
Let me add in defamation of character. The plaintiff is on a duty to prove intent, and intent to injure the character of the plaintiff. Proving intent is not very easy to do. And so where you cannot establish that the defendant said all of these things, knowing fully well that your character is what you call it, protected, it is kept, honor, purity, and that you are not the one that the defendant is saying all of these things about, meaning that there are no proof to say that you are a criminal. There are no proof to say that you didn't do any of the things that the defendant is talking about. The defendant could come to court and say, yeah, I said all of these things. Here are the evidence that I have to be able to establish that the defendant, in this case, Musa Bility, is a fraudster, or Musa Bility is a criminal as alleged. So as it is, I understand that the writ of summons along with the complaint has not been served on Senator Dillon.
But Councillor, what if we in these days of social media, what if it is established, or we have the recording of Senator Dillon actually calling Musa Bility a fraudster and a criminal? Is that enough for libel?
You know, the court
slander.
The court does not make decisions based upon what the public thinks. The court will have to look at the evidence, scrutinize it very critically to be able to say, okay, Dillon, you said, Senator Dillon, you said all of these things that the plaintiff complained of, and they are proof. And if it can be established after critical scrutiny of the entire factual matter that the plaintiff is complaining of, then the court will not make a decision, but the jury that's sitting down there, they will go, the court will instruct the jury to go into the room of deliberation, go and look at the facts in this case, and come back and tell me whether you all agree that the defendant Dillon said all of these things. And even if you agree, do you also agree that 1.5 million or 1 million should be the damages? The jury will go, maybe it can take 2 days, 3 days, depending upon.
Councillor, here's my question, because what the easier one that can be, proven here is the tape or the podcast stating that this person said XYZ, because a lot of things have been said about people on social media, any of the podcasts, the platform, or the talk show you pull up, people are insulting people. People are saying all kinds of things, charging people of being corrupt, of being criminals, and all the 9 yards. Would those be enough? Would it be sufficient enough to say, yes, you said this is considered slander, is you are liable, you have injured his character?
So Musa Bility is on a legal duty to produce all of the tapes you're talking about.
Right. Let's say he produced them. What happens?
He on a legal duties if he did not have those tapes before then to give notice to the court that during the hearing of the case, he will ask for a subpoena to be served on whosoever that have them. He also on a legal duty to produce factual witnesses that will come and testify to what Dillon has been saying. And along with newspapers and whatsoever thing he believes. And if the evidence critically examined by the court, first examined by the jury, they are the trial of facts, they will say all of these things that we have reviewed, we consider that Mr. Dillon, Senator Dillon committed is liable for defamation of character, and that he injured Mr. Bility, and so he should pay the amount. Then the court will pull them, will ask each of them, bring them back in the courtroom, ask each of them, is this your verdict? Is this your verdict? Is this your verdict? When they say yes, the court will then be required to enter, will discharge them, and then enter a judgment consistent with the verdict returned. The court could say the verdict, could set aside the verdict and say the verdict, meaning the decision of the jury, being contrary to law, this court will rule A, B, C, D, contrary to what they have said. Or the court could affirm and reconfirm their findings.
So proving that you said something against me, if you get up now and go on social media and call me a criminal and call me all sorts of names, okay, just by mentioning those names, And we are seeing the evidence that you actually said this on Facebook.
Mhm.
I can sue, or is there anything more than that for me to sue for damages?
So in order to sue, if you intend to sue for defamation of character, you better make sure that all of what the defendant has said, they're not true.
It's not true, okay.
You also should make sure that they were said with malice and intent to defame.
Oh, of course. I mean, those are not praise words. Nobody is going to say, "Yes, you are
Malice
crazy."
and intent to defame your character, and your character must be clean.
Okay. So in the case of Musa Bility, because people are using his FIFA case to say, hey, here he was accused of this in the FIFA case. He was accused of this in the RIA case. There were some friends who sued him for business. Can any of those come into play to say, well, because of this, so Dylan was right to call him a criminal and a fraudster? Should he be convicted in those cases for him to be called that? Or
so Dylan will produce all the document, all the instances you're referring to, all the documentation you're referring to as a defense. A good lawyer will request a court will subpoena for subpoena duci tecum, or subpoena ab testificata, subpoena to come and testify, subpoena to produce document against everything that they know about Mr. Bility to be able to say, look, this guy is not, for the jury to see that this guy is not who he say he is. And if the jury buy into the fact that he got all of these shady records, I don't say he has shady records. I mean, those are the documents that Mr. Senator Dylan will produce, and the jury say, wait, this guy is not who he says he is. We can't grant him anything that ends the case unless the judge will set aside the verdict of the jury. But they prove to say that your character is injured with an intent to injure your character rests on you.
And if he cannot prove that, what happens?
Oh, then in fact, this is a civil matter. After the witnesses are produced on Mr. Bility's side, the plaintiff will also, I mean, the defendant, meaning Mr. Senator Dylan, will also bring his evidence, and then the court will instruct the jury to go decide whether they have heard enough and think that Dylan actually injured Bility's character. And again, I say there must be malice and intent, and you better have a clean and clear character. Because as a good trial lawyer, I will subpoena everything I know about you to prove that you're not what you say you are. In fact, you don't even have a character.
And when do you subpoena that? Before the trial, during the trial?
Well, during the trial, when you put your witness, I assume Mr. Bility will get on the stand to testify. I will cross-examine you. On so day you did this. Is it true? Were you consider a fraudster in any kind of deal that you committed yourself to? And you say, no, I will show you a document that you committed contract fraud, if that exists. And the thing about it is that a good lawyer will be able to tear everything down because there are enough of information out there.
Yeah.
That you can cause
and the reason I asked that, because in the Cummings case, they were asking for document in discovery. Can you do the same thing in the Bility case to say discovery?
In a civil case, the complainant is required, when he filing his complaint or her complaint, he or she is required to attach an Exhibit 1, all of the things rely upon to sue. Exhibit 1, Exhibit 2, Exhibit 3, Exhibit 4, unless the original of any of the exhibit is believed to be residing in custody of the defendant. Then you can ask for a subpoena duci tecum to be served on that defendant to produce the original document.
Last question on this. It said the action of damages by attachment. That's the one that was filed. What is that, and how is that different from action of damages alone without the attachment stuff?
Being a practicing lawyer and the amount of experience I have, I highly will file an action of damages with attachment. Why? And what is an action of damages with attachment? when you file an action of damages with attachment, you are saying the court should require the defendant, when the writ of summons is served, the defendant should be made to identify property or money in his account to indemnify the plaintiff, so that if he or she wins, the money can be available, or the properties can be available to be exposed to sell their property auction, so that the money, the 1 million, 1.5 million that they're praying for or they're suing for, can be available. So it attaches and secure those pieces of property for it to be used for auction purposes. It attaches your bank account if you have money in there, so that when the judgment is done, the matter go to the Supreme Court. The defendant lost the case in the Supreme Court, and then the items are there so that the judgment can be certified, meaning that the money judgment can be paid. Or if the defendant has no property, no money, arrest him or arrest her, bring her on the jurisdiction of the court.
And you will see the intent, right? Because the lawyer here say, you must give me the money, so you got to.
But Dennis, I said something that I would not, as a lawyer, I never play around attachment a lot, because reason is that the defendant that you're suing for damages with attachment, that defendant has a right to file an answer to your complaint within 10 days. File a return to your attachment proceeding, and file a bond 2.5 times the amount that you're suing for. And the judge would then lift the attachment. But in this case, in the Dillon case, it's quite interesting. When you file a complaint along with a complaint with actual damages by attachment, you're asking the defendant to identify property or money to be able to certify the judgment. But Dillon is not an ordinary person. Dillon is a senator. And Article 42 of the Liberian Constitution said that while the Senate or the House of Representatives is in active session, the senator or the representative cannot be dragged to court. So if I have Dillon lawyer, I listened to Mr. Dillon when he called one of these shows and said that he has now gone to court the writ of attached, what you call it, the complaint, the writ of summons, and the writ of attachment, along with have not been served on him, or that he had not received it because the brother died, and he called the judge wanted to bang out to bury the brother. When the judge returned, he will go to court. I would not tell my client to do that. We'll file, if I represent Dillon, we'll file our answer within a period of 10. We allow ourselves to be served. It's not the court, not the lawyer that is served. Dillon will receive copy of the attachment. Dillon will receive copy of the writ of summons and the complaint. And then within 10 days or before the end of 10 days, we'll file an answer to the complaint. We'll file a return to the attachment that is prayed for. We'll file a motion to dismiss on ground that the Senate is in session. No senator can be summoned or sued.
So
and then we'll file a motion. That motion will be to dismiss the matter on ground that the Senate is actively sitting.
Like in the FIFA case, Bility did not go to court in the FIFA case, but he was found guilty. Can that be considered criminal, even though it was not done in the court of law?
So it goes to your moral character. I heard Johnson arguing that there was an administrative proceeding, but anything that causes your character to be questioned could end up with people believing that even though you were not convicted, in court you get convicted, in criminal court you get convicted for a crime. In a civil action, anything that turned to prove that your character is not as what you claim it to be, is enough to say that the lawsuit filed by you is not materially strong enough to ensure that you recover the damages. Here are the reasons why, and they will lay out those reasons.
But based on the FIFA case, for instance, since it was not a court, you can't call him criminal.
Well, what if FIFA, yeah, in the other case, what if FIFA did was to, I guess, suspend him from attending all football games.
Right.
And I think, I didn't follow the judgment, but I think FIFA is requiring him to pay. And I understand Mr. Bility has, I think, appealed to a higher administrative organ in there. Again, I'm not saying Mr. Senator Dillon did not call Mr. Bility a criminal. I'm not saying that Mr. Bility action may not be actionable, but it requires proof. And during trial, the lawyer for Senator Dillon could say our client did not call Mr. Bility a criminal, or our client called Mr. Bility a criminal because his character is not clean. And here are the reasons. And they could lay those out.
Thank you. My last question will be on this guy because, I mean, he's interesting. I want to talk about him a little bit more.
Look at you as model, role model, I mean. So on the basis of this, whatever you do, people look at you and follow. Our young generation look at us. Whatever we do, they feel that indeed it is part of the status quo and the norms of society. So when people engage in antisocial behavior that is counterproductive to the normative structure of society, there is a need to call them to book. That is the situation. Dr. Bility is a man of substance, a man with the dignity of labor from the most supreme and noble, man with regularity and the tenacity of purpose, who imbued in him the virtue of love, affection, and general human.
The tenacity. It will interest you that Councillor Johnson in 2020 threatened to file a lawsuit before the full bench of the Supreme Court of Liberia if any attempt is made by President George Weah to release his fifth album, his fifth single. So he said, if George Weah sing another song, I will sue him. Since then, George Weah has produced, I think, 2 more singles.
You know, when lawyers, when client, it depends upon the client you have before you. I think Councillor Johnson may be justifiably arguing for the amount of money he charges his client, which I think is unethical. But he trying to address him so nicely that if the retainer fee were $200,000 to represent you, you would pay maybe 50% quickly, or even 75% of the money. So again, I think Councillor Johnson needs to be controlled. I think the Supreme Court lawyer representing Mr. Bility can take his complaint to another Supreme Court, to criminal court, to civil law court, rather, not criminal court, go to civil law court on the information that the lawyer is arguing the case in the public and calling press conferences here, Diana. You are muted.
Let's look at the last case quickly, and then we open our phone lines for our callers. So there was this during the Cummings court case, there was commotion in the court. Some fighting broke up, and as a result, ANC leaders and LP leaders were sued. The complaint was filed by 2 officers of the LMP, that's the Liberia National Police, Patient Colley and Victoria Davis, along with a Monrovia City police officer, Victoria White Davis, all assigned to the courtroom. And this is what it says. Your Honor and Honorable Court, they want to hold the defendant liable under the tort doctrine of respondent superior, and the defendant be ordered to pay plaintiff the amount of $1.5 million in general and punitive damages to be decided by the jury, and grant into plaintiff any and all other relief that your Honor and this Honorable Court may deem just, legal, and equitable. So they are suing Cummings and Bility, say the fighting that broke out, that went on in the court, you allow it because we told you not to bring this amount of people in, you brought them in. Now we're injured, so pay us $1.5 million.
So anyone can file an action on damages for injury to person, an action on damages for wrong before the civil law court. You'll be required to establish your complaint. It's a civil case. It's not a criminal case. So you see Mr. Cummings will be cited to appear along with appear and file his answer in Liberia within a period of 10 days. And that failure to appear to file your answer within 10 days before the civil law court is a ground for the plaintiff to pray for a judgment by default, meaning that a case will be heard, place Mr. Cummings on bail denial, meaning that Mr. Cummings did not appear in court. The case could be heard. Mr. Cummings and Bility could appear in court. So a judgment should be rendered against them, and they should be made to pay the general and punitive damages. Punitive damages is a damages to punish you for some wrong, intentional wrong that you committed. And they invoking the doctrine of respondent superior.
Right, but how are they able to connect Cummings and Bility to the riots and to the action of people that are making a mob?
You know, I was looking, I think it was last week, I was looking at, I think, Frederick radio or one of the journalists, one of the radio stations in Liberia, interview a couple of women, I think good, I think about 3 or 4 women. And the women said that the women chair of the ANC, and I think the deputy chair, had gone about sending buses all over town to bring people from where they are residing. Some of them said it from Gardnerville, some of them said it from, what do you call it, place? I think Bannerville, some of them from New Jersey, other places around Monrovia, and brought them to court. We're not really bringing them to court, but they were told that Mr. Cummings had promised them some money earlier.
Right.
And this amount of money, the chair lady of ANC and I think the deputy chair lady, I encouraged them to come because Mr. Cummings was ready to give them the money. And so the women then got in the buses. And if it is true that the chair lady said those things, and those women were brought to court in buses or brought on capital bypass and dumped on a capital bypass in buses paid for by the chair lady by and through Mr. Cummings and Musa Bility, then the action of those people, and the other thing I honestly is that good number of from both sides, from the Mr. Cummings side, good number of people went to the court, and from the government side, I think the people who went and tried to occupy the magistrate court and were chanting rather every opportunity they got to praise their leader or to support their leader and so forth. If it can be established that those things were done, Mr. Bility and Mr. Cummings got some legal thing to answer in the civil law court. If those tips, if I'm representing the plaintiff, I will gather those tips and I will find a whereabouts of those women that they brought. I will find how many buses were sent for them. And I will find the drivers who drove the buses. And I will bring good number of the women to court to testify as my witness or witnesses for me.
Right. Councillor, give me a break. Yes, they are. I think this is what you are referring to.
Okay, so you said you were actually, if you fed them, you had the crowd running over you. So how are you going to get home now? And how are you going to get treatment for the wound? Also, if you do have transport to come or to go home, well, how are you going to get here? They said we're coming for different projects, but before we tell example to do people, we don't believe. So now you got to order, we come here today for different projects like the project we know we here for today. And that we can the process, but sometimes all the process coming for projects, they say, project as you would I say example you put so come to come project. They say, but now the project all we want home. They say coming for the money now example we promise all of all today. So the reason we can get a cost for all. And now our sister get our mother in basic action with big girl with us. She fell down and when they cry, she fell out when they cry, they put girl at the hospital. Now they need me the girl right now.
Councillor Jayweh, that's the tape you are referring to.
Yeah, and I will also add that I heard.
So in your view, that can make the connection that indeed Mr. Cummings and Mr. Bility are responsible for what happened in the court?
If the plaintiff can establish that by those witnesses that they were brought for they were misled and brought to town on buses that were paid for by Mr. Cummings or Mr. Bility, Mr. Cummings and Mr. Bility, and that they were in fact brought to now protest, as the woman said, and not just coming to get the money that Mr. Cummings promised them, as they were told. And so they had no money to go home and could not even get back to where they came from because the buses have disappeared. If it's true, I, as a trial lawyer, will find those buses, find the drivers, find who chartered them, find how the women came to court. And I will ask the court to subpoena the quote-unquote leader that she's referring to come to court and say how, why were the number of people brought to the court? The courtroom is not a theater where people clap for the hero and, who win and who did not win. The courtroom is a very serious place. And I also listened to one of the seasoned person that supporting Mr. Cummings and said that Mr. Cummings had a right to have supporters, at the court to support him. At the courtroom, supporters don't go there to support people. You got a case, that's how you go into the court to be able to be heard. But you don't go there to clap. You don't go there to cheer people. You better stay outside the confines of the court, because if you brought people to support you and under that process, people got injured, they have the right to sue.
Thank you, Councillor. Let me bring in our first caller, and that's James David. James David, you are live. Question or comment, sir? Sorry, James. Go ahead. You are live. Question or comment?
Yeah, my concern is about Musa Bility, because I think the government also had a problem with his character, because we were buying gasoline, he was supplying, and he was taking 30 cents from every people that buy gas from his company. And up to now, I think it's still old government. He didn't pay the money, so it's not that contributing toward his character too.
Thank you, sir. Councillor Jayweh.
Mr. Davis is raising a salient point. Senator Dillon and his lawyer would do well to subpoena every document, every testimony, every transaction that Mr. Bility has ever engaged in from the day he knew himself as a man of character, as an adult, and prove that, contrary to Mr. Bility's claim, here are the facts that show that he has no character. Here are the facts that show that he committed, there was a tax case. There was a case against the government, I think, where Ellen Johnson's lifetime. Mr. Bility was taken to court. All the records are there. As a good lawyer, defending Senator Dillon, all the documents I will pray the court for subpoena, including Mr. Bility to produce all of the court cases. Again, that's another interesting thing, including Mr. Bility to be subpoenaed to produce the original all judgment that was entered against him from the court.
Thank you. Joseph Cockroach says, in the case of Dillon, can the plaintiff be compelled to prove intent, or can the jury be instructed to consider intent during their deliberations?
Yeah, the burden to establish by preponderance of evidence or the weight of the evidence, resting on the shoulders for this time, right now, on the plaintiff that filed a lawsuit. And also the defendant may argue that, we say all of these things, but we have no intent. Because intent is difficult to prove. Yeah. And the jury could say that, wait, let's look at the main record. We have about 100 files containing this man, his activity, with the gasoline thing that Mr. Davis mentioned, with when he was a member of the board of LACC,
All right.
The Alan Courtroom and him were alleged to have signed some documentation or everything that material.
Right.
To this case, we brought a jury will be, they will examine the documents and say, this man got character or he doesn't have character. Mind you, these are ordinary people who will be passing on that kind of judgment.
Right. Willard Dombase, he first has to have had a character for DeLon to defame. I'm tired listening to this conversation now. I want to also believe this lawyer, meaning you now, want to try his luck representing Bility.
Oh. I think this is the woman who said last time, you're nonsense from here, right? Oh, she's interesting.
All right, let's get one more caller. This is John Mawolo. John Mawolo, you live?
Yeah. How you doing? Listen, Mr. Lawyer, there are a couple of things I see you're not consistent with. The first thing is that last story you're explaining about the woman talking about somebody brought her has nothing to do with the fight that happened inside the courtroom on the first day that they're suing for. Besides, the witnesses go in the court to monitor the case. So nobody was stopping in there. So you need to get the facts of that matter right to, say anything about. Now, from what I noticed, if you the criminal charges against the ANC or Mr. Cummings is, for you, is an easier case to litigate than the civil case of somebody on tape. How do you prove the internal forgery, or how do you prove forgery unless you got two documents to compare? If one person, if you don't have the other document, how do you prove that forgery was committed? The second thing would be, based on what would you accuse somebody of forgery unless they have an intent to forge whatever document it is. So to say that, you can ask the person for a document when you should know, at least as a lawyer, that the NEC will not accept a copy. It will take only the original, and everybody else has a copy, where 4 Secretary General are represented on the team that made the copies for each team. How can you come to such conclusion?
Thank you, John. John, are you saying that the original is with the NEC and also all the 4 political leaders have originals? Is that what you're saying?
No.
Where is the original?
The original is with the NEC.
All right.
Every other document is copied.
Thank you.
The other ones, each one of them has a copy of that original.
Thank you.
Because their Secretary General served in the Secretariat.
Thank you. Let me go to our next caller. That's Jayweh Gigan Boma. Jayweh, you're live.
Thank you, Dennis. Thanks for this show. Great conversation with the learned counselor here. But I beg to differ on so many grounds. I mean, first of all, I think the counselor needs to actually be balanced in how he describes incidents, or how he describes both sides. Because on one hand, he will use some tones on the Cummings case, for example, instead of accepting that the Cummings lawyer exercised their right to go to the circuit court to get redress based on the decision made by the lower judge, Juma Jala. He said they fled. That kind of language, I mean, to me, it shows, it signifies a sense of bias. They did not flee. Okay, they exercised their right to go there, and as a lawyer, he should know that. And then secondly, another thing that is worth knowing is this. The tape that you just showed about these women talking about someone sending buses for them, it has nothing to do with the fighting that happened in court that they are trying to charge Mr. Cummings with. This was during the Solidarity March. The buses that these women said they received, it was during the sort of Solidarity March that happened in Monrovia. It was not during the court case. The fighting in the court was completely a different matter. This is when Mr. Cummings went to court. And
Thank
as
you.
a matter of fact, during that court case, several ANC supporters were told to leave. You can go on Spoon, they will be there. They were asked to leave the building, and a lot of them were complaining. Serena Cephas went into court and told them that ANC officials should leave, and they did. And secondly, the government has officers. They should have security protection in court. So how is it that fighting open in court in the presence of security officers, the code that has been administered by the government, but then Mr. Cummings get charged?
Yeah.
I find that difficult. And lastly, again, and sorry for this time, but lastly, let me let this counselor know. You have to be honest. And I know if you're going to represent people, one of the things that is required, legal ethics, is being honest with yourself. When you say that you have to go to court and immediately demand a proof of evidence from the defendant without going to trial, I think that's a statement that you might want to restate. You cannot just go to court and say, I'm suing this person, I want them to provide defendant, or I want them to provide evidence. You sue them, and if there is no plea, no one has taken the plea, no evidence or no witness has been put on the stand, but then you are asking the defendant to provide evidence against himself. Are you saying that this is how Liberian law works, sir? I will stop and listen for my answer. Thank you, Dennis.
Thank you. Let me take our last caller for the night. That's Oliver, if I'm correct. Your name and where you calling from? Is that Oliver?
I'm calling New York City.
Your phone name, please.
Hello, can you hear me? Hello, can you hear me?
Yes, I can hear you. What's your phone name, please?
My name is Oliver Zodua, calling from New York City.
Oh, okay. Zodua. Go ahead, sir. You're live.
You guys are doing a good job. I was just trying to talk to the counselor. Jayweh, I don't know what I was pronouncing well.
Jayweh.
Thank you so much. But my question was that you don't think that you're educating all the people when you're supposed to do that research, doing all the research for them, and at the end of the day, now they have a lot of the punches to throw each other because they have all the proof that you have been given because you have been a professor for a long time. And that's the same thing, we said the last time, which was last week, this week. We said 80% of our potential brothers and sisters are out of the country. And this is something that you are proving. When you are educating the truth, both of them to try to find a solution when they're supposed to do their own research, because usually the lawyer have their own research group that's supposed to do all of that. Are you telling me right now? And at the end of the day, so because of that, our research group going to get free pass and get paid. So you don't think that you're doing a good service, but at the end of the day, you don't serve the job to all. Secondly, maybe you're looking for them to hire you for you to do your job. That's my question. Thank you so much for having me.
Thank you so much, Oliver. Councillor Jayweh, the question comes again. You say you're doing too much. Are you auditioning yourself for any of them to hire you as lawyer? But you can pick.
No, I don't work for the state. No, I don't wish to work for Mr. Cummings. As a lawyer, I'm only explaining what the law is. When a subpoena is prayed for, either by the prosecuting attorney or the defendant and his counsel, in other case, the court would demand or the court will enter a ruling to say that the original of the document talked about should be brought, because under our law, the law says that the best evidence that a case admits of must always be produced. And if they claim that the forgery that occur within the confines of Mr. Cummings, the state have the right, as well as the defendant, to pray for a subpoena. In this case, the state prosecutor prayed for a subpoena. And so the subpoena was granted. The matter is now before the court. I used the word Mr. Cummings and his client fled to the circuit court. And it seems to be offensive to, I think, one of the callers. When you have 72 hours rather, to file, to produce the original copy of the document. And on the second day, you proceed to the circuit court, hoping that you can find shelter within the circuit court. It could be termed or considered as to protect your client, you run to the Supreme Court.
Right. Maybe you could use ran instead of fled. Maybe that's why, I don't know.
Or you have a right to, and I said it's summarized. You have the right to disagree with the ruling of the magistrate. And maybe the better word could be summarized the magistrate and to proceed to the circuit court, criminal court A, and defend his ruling. It doesn't mean that I'm saying Mr. Cummings is guilty. That's not what I'm saying, because I don't really have the facts in my hand. The other thing is that I don't wish to be hired by the state. I don't wish to be hired by Mr. Cummings. I'm only trying to educate the public that the prosecution proceeded legally to ask for a subpoena to be served on Mr. Cummings, because it is believed that the original copy of the document resides in Mr. Cummings' custody. Again, the state decided to subpoena Mr. Cummings and not the what you call it, the NEC, National Election Commission. If I were the lawyer again on that case, I would subpoena that the Mr. Cummings as well as the NEC produce what they have for the court to have it in the process of discovery. In the prosecution case, they chose to subpoena Mr. Cummings. And producing those documents does not mean Mr. Cummings is guilty. It is whether the document in question was forged. If the state can establish that forgery occurred, then in that case, the magistrate could find him guilty. But I'm not saying he's guilty.
Okay. Timothy Nancy, you are obsessed with Mr. Cummings.
I'm going to explain it. Our country has been in the news recently. And one of the reasons why the country is in the news is that because Mr. Cummings is taken to court. And I said, as an experienced lawyer, I would have made sure that, my client being a political person, I would have made sure that, this matter was handled at the CPP level and handled amicably in a conference, then going to court. But if that failed, anybody, where Mr. Jayweh felt that forgery was committed, Mr. Jayweh, as a private witness, can ask the government to prosecute for forgery.
All right. Howard Mesga said, weak opposition, they will be talking and fighting while election is next year. They will be fighting until this gangster paradise come over here again. When will the opposition start civic education? Why they bickering? They are yet to condemn these illegal things toward our people daily news and on a daily basis. Who tagged me here? Please, I'm resting. Continue resting, Howard. I thought you were resting, but it looked like you were not resting.
No, she's fighting. She pretty much been fiery.
Also, if Samukai had a problem with the code, why NEC allow him to take part in the Lofa election? That's a big question that keeps coming up again and again.
Yeah, so there's a reason. When Samukai was taken to court and tried, he was convicted during the period the election was going on. Even though he was convicted by criminal code C, Mr. Samukai and his lawyer announced appeal from the judgment of criminal code C. Once the appeal was granted, every other action on Mr. Samukai case had to be stayed or had to be prevented until the Supreme Court could determine whether the judgment of criminal code C should be upheld, and Mr. Samukai and Joseph Johnson and Newman Docker be today considered as convict, whether the Supreme Court were going to uphold the ruling of criminal code C. In that process, Mr. Samukai, not because he was convicted by the lower court, he was not a convict until his appeal could be decided. So the court, the government, after the case was decided by the Supreme Court that they committed a crime as charged, they became convict, and their civil rights was suspended. The right to vote and be voted for was suspended, even though he won the election, he could not be permitted to take his seat because he was then suffering illegal disability.
Right, and at that point, others are saying it is his colleagues in the Senate should do that now and not the court, because
well, no, in order to sit as a senator, you must be certificated by the Election Commission.
And the Election Commission allowed the Supreme Court authorized the Election Commission to certificate him.
Yeah, that mandate was before the Election Commission to be read. I guess the mandate was read so that he could be certificated before the Election Commission could go ahead and certificate him. The government of Liberia fled. Again, let me use a word so my friend will feel good. The government of Liberia took the opportunity and went to filed a petition for prohibition to prevent the Election Commission from certificating him before the justice in chambers. The justice in chambers, which is His Honor Justice Jayweh. Justice Jayweh sustained, there was one political party, MPC, a movement for progressive change, something like that. They were the one that filed a lawsuit, and the government later on filed, I think, an intervention to join the lawsuit. Justice Jayweh sustained the decision not to certificate Mr. Samukai. Mr. Samukai lawyer announced appeal and went to the Supreme Court. The Supreme Court agreed with the government of Liberia and said until Mr. Samukai and the other two co-defendants have paid the amount of money in question, they should go 6 months, give them 6 months to pay the amount. And I'm saying that if Mr. Samukai and the other co-defendant had paid the 50%, today Mr. Samukai would be sitting. But he paid more. I think he paid almost $200,000. And the other people paid maybe $1,000, $2,000, which were not.
Last comment here before we close. We have 3 minutes left. Let's suppose Cummings says the document can be found. They lost. Or, the rat ate my homework. I can't find it. What happens?
I don't know what the state would do, but I would say legally, if the original of the document cannot be found, then the state will not have a leeway to introduce the copy they have as the only evidence, because the law says that the best evidence that the case admits of must always be produced unless that best evidence cannot be found. So if the best evidence cannot be found, Mr. Cummings say, this thing, I can't find it, or it got lost, or if the state want to, they can now subpoena they could subpoena the Election Commission to produce what they have, or they could use the exception to the rule and use the copies they have in their hand as the evidence to prove that forgery was committed. In fact, it's not because the state say forgery was committed, so forgery was committed. The court will examine critically all of the documents to determine that forgery was indeed committed.
Thank you so much. I think Joseph Control said this, so we're not going to repeat it. Councillor, thank you so much for coming and providing the education that you did. Clearly, there are others who don't agree with you, and I think you saw that, and there are others who agree with what you said. But in all that, this is what the show is about. Thank you so much for coming and volunteering your expertise. Your closing comments, sir.
Well, this is it. First, I want to thank the show for inviting me. I think such information will be very necessary for all of us, particularly people who are not lawyers, because the technical things that happen in the courtroom may not be agreed with by everyone else, but that's the law. And we will follow the law until we find that nothing else that is there. It helps our democracy. It is responsible for peace and order in the country. So I pray that all Liberians will pay very good attention to why Liberia is currently in the news. Thank you.
Thank you so much. We want to thank our viewers for watching, and even all those who will watch later. Keep it here on Focus on Liberia, where we educate, we elevate, and promote all things Liberia. Until then, we close with our song that says, we are all Liberians. Whether you agree with what has been expressed here by Councillor Jayweh you agree with either side. We are all Liberians, and it is incumbent upon us to do whatever it takes to make Liberia the glorious land of liberty. Have a good night, and God bless you.
We are Liberians. Liberia is our home. Liberian people. Liberia.